Hello, I want to walk you through dispute resolution. Um, you're probably tired of listening to these. No, I'm a little tired of making them. Anyway, this is chapter 4 of Beatty and Samuelson. The slides are drawn from another textbook, but this stuff stays pretty solid. One of the first things we want to look at is there a way to avoid litigation? Um, and we don't always walk through this. Who best to decide? The plaintiff may force it on us. We may think that we are better off litigating before the other side litigates. But one of the things we're always going to find courts looking out for is the issue ripe for decision? First of all, does the party that's making the allegation have standing? If my cousin brings a lawsuit on my behalf for injuries I received, obviously they do not. You'll find standing used a lot by the government to say, no, that's not something a citizen can bring, that's something a department or a business or others can. So it's worth looking at, not always there. The courts don't like advisory opinions. That is, they're not going to, in the middle of a process, tell you who's going to win. They're going to wait until it all plays out and then go in and look at it. So don't be expecting courts to say in advance who might win a contract dispute. One of the best uses for court, although the hardest to obtain, is injunctive relief. If we've got somebody infringing our trademark or infringing our service mark or engaging in defamatory conduct, we may be able to go to a court and say, hey, can you get them to stop? A good example of injunctive relief is a cease and desist order or an order of protection, routinely issued on just one person's say-so. Not made permanent. You can go get your boyfriend, he can't come over to your apartment for the first 20 days of the order, but they're going to get a hearing pretty soon because we don't like to relieve people's right of free movement, or end it, rather. The next item is, are we going to be filing in law or in equity? Now, this has kind of disappeared over the years. It's still there. I don't want to say get rid of it completely, but generally equitable remedies have folded into the law and legal remedies have folded into equity, and it's all sort of there. But if we get on appeal, oftentimes we may need to know whether we're there, but whether we're in law or equity. And lawyers may speak in these terms to you, and it can be a little confusing. But the law tends to come out of statutes, but at the same time, equity is usually divorce court. When we're looking at jurisdiction, we need to look at whether this is jurisdiction over a thing, that is in rem, property, a car, or in person, that is a person, or a corporation. An entity is in personam. Now, we may also be suing people who are employed by the entity under individual liability point, but we've always got to be careful that usually the entity has the money, the individual may not. All right, so generally in litigation, and this is civil litigation, all right, this is not criminal, a party files a complaint, okay? They have to identify all the parties. Sometimes we might let something go all the way to jurisdiction, to judgment, because they didn't name the right party and they never asked us who else was involved in this, etc. You'll see a lot of businesses are set up with a multitude of entities that operate inside a single shell. To pick on Trump, this is very frequently how his businesses are organized. There's a shell that holds the title, if you will, to the hotel. Then there's a restaurant company. there's a lodging company, there's a maintenance company, there's the golf course company, blah, 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 blah. And so as the plaintiff, we've got to be careful that we sued the right entity. Now, if they ask, if they ask, we have a duty to tell. If they don't ask, it's just like, you're buying a car and you say, hey, is there anything mechanically wrong with the car? The person has a duty to reveal. If we don't ask, no duty. Okay? Caveat emptor. This kind of applies here too. And caveat emptor means caveat, let the buyer beware. So basically the complaint, once we get past this party deal, they're going to have to say facts. They're going to have a claim upon which relief can be granted. That is there a legal remedy out there that works, or is there a good reason to extend remedy, to extend law, to make a remedy for this situation? That's kind of where law and equity flow together. Once this has been served on us by, or served on the opposing party, they either have to file an answer or what's called a dispositive motion, or potentially a motion for more definite and certain. That is, we don't have enough facts in our complaint, or we couldn't really figure out exactly what's going on. We're not certain we have the right entity here. Please help us out. Pardon me. We may also file a cross complaint. Let's say that this is a company suing us because we didn't furnish them the right equipment. Well, we might cross complain back that they damaged the equipment we did furnish to them. All right. We may also have affirmative defenses. A simple one is the statute of limitations. You have a certain amount of time in which to file a lawsuit. It may be that the doctrine of lashes applies, or it may be that, say, we are a government entity or a nonprofit, and under a statute we're immune from suits like this. We would have to raise this right off the bat, or we may waive it. W-A-I-V-E, that is, it goes away. Assuming we get past all this, we then go into pretrial discovery. And I should probably pause a long time here, because this is where a lot of expense comes up for parties. Okay? Just getting into the discovery phase, this is kind of, as a practicing lawyer, particularly a defense lawyer, this was my bread and butter. This is where I made almost all of my money, was in pretrial discovery. We tried to settle these cases as soon as we could if we thought we had to, but we always tried to settle them after we had engaged in the discovery so we knew the real value. So the first thing that goes out are written interrogatories. These have to be answered under oath. They can take a long time. They're very legal in the way they're phrased. You got to be very careful here. Anything you put down is binding against you, can be used against any witness in this court. Next phase is depositions. Please raise your right hand, place your left hand on the book of faith, although they don't do that in depositions. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? And some reporters say, so help you God, others don't. And swear or affirm is a new one. You used to have to just swear. We recognize that there are people who, for a variety of reasons, do not swear. I believe Muslims do not, but I'm not dead positive on this. But there are certainly atheists who are going to say, I don't swear anything to God, I don't believe in them. But we still need some kind of an oath. And the questions are, it's a back and forth. The trick, if you are a deponent, answer only the question in front of you. Keep your answer less than 3 sentences. You've answered almost any question in a deposition if you've spoken for 3 sentences. And shut up, wait for the next question. Each party is entitled to do independent inquiry and investigation. The states are all over the place as to whether you have a duty to share that with the other. Missouri and most of the other southern states say no, independent inquiry is just fine. States like Illinois and Iowa are much more, you share everything you've got, let's resolve this. If we've got personal injury involved, we oftentimes have medical examinations and we take depositions of the treating physicians, or we may be able to send somebody to an examining physician. Um, we lawyers tended to call them whores. Not a very nice phrase, but they were people who tended to see the world through a singular lens. The defense doctors didn't see anything that a greenback poultice wouldn't cure. That is, you give these folks money and they'll be fine. The plaintiff's lawyers would tend to take a minor cut and turn it into a life-threatening injury. We get some of the same thing with other experts. A lot of experts are, things like time lost experts or time value experts, ordinary wage experts, somebody who's an expert on how well trained this person is, a product expert, an expert on driving a truck, for instance, if we've got a truck accident. Big field. Experts can be very expensive on both sides of the aisle. There's kind of there's a whole bunch. There's a cottage industry in experts for trial. All right, a couple of other big items that come in. I'm not sure our text covers them, but they do happen. Intervention and interpleader. Intervention may be, oh, I know there's a lawsuit going on. I need to get into it because if I don't, I'm going to lose my rights on it. Okay? Interpleader is the one I saw more of, and that's just the nature of my practice. But let's say that we have an automobile policy for $100,000. It's a front-end collision. We've got a death, 2 horribly injured individuals, and 1 not so bad. $100,000 is going to go away in a hurry. The insurance company is going to go, this is the extent of our liability. They'll plead it into court and let the injured parties fight it out as to who gets what. Okay? State Farm's out of the picture. They put their money in, they're gone. They cut their losses. Not so easily available generally to general businesses. The other one, the intervention, sorry about the kind of lengthy talk here, but it is sometimes used to defeat or create diversity of citizenship, so that we may actually get diversity through bringing somebody in, because we may have a plaintiff and a defendant who are both of the same state. I'm trying to make sure this works. I get a little lost here in diversity of citizenship. I know I should, Professor, I should know everything, but I don't. I just don't remember everything. But we will maybe bring another party in. We'll ask them to intervene in the lawsuit. And this is oftentimes done to make sure that all the parties have standing to get this resolved. Once we go through the discovery process, which in federal court is oftentimes limited, you've got 9 months to do all your discovery. We're going to court 3 months after you guys are done. They give us time to, make sure we've got everything done, but once we get within 2 weeks of a court date, ordinarily there's no pushing that back. At trial, the judge is to interpret the law. Now, in the other one, if we don't have a jury, the judge also finds the fact. Generally, we're going to go to jury trial because the plaintiff is ordinarily going to ask for it. And once the plaintiff asks or the defendants ask, either side under the Sixth Amendment, we're all entitled to the right to trial by jury. Fabulous provision of the U.S. Constitution, and that applies in civil cases as well as criminal. It's really a powerful thing. Controversies of $25 or more. That, of course, we've added that. Wait, $25 back then bought a lot more. It's about $75,000 nowadays. But and that's something I forgot to say in the diversity of citizenship, you've got to have a controversy in excess of $75,000 to get that removed out to federal court. But that's just a matter of allegation, and it's got to be very close to that, or the court will say, hey, wait a minute, you just don't have enough controversy here. The jury is selected by voir dire. The book I pulled this from said that this is truth speak. It is not. Voir dire is see speak. Vrai dire would be truth speak. And so this is really an opportunity for the lawyers to see these people and kind of to see whether they are truthful or not. I can go on for a long time about juries. I'm a big fan of juries. I really like them. At the end of the case, we have the right, either side does, to poll the jury. Is this your verdict? Periodically, someone will say, no, it's not. So most lawyers go ahead and poll the jury at the end of case just in case, because that may be fabulous. Someone says, no, that's not my verdict. They talked me, they forced me into it, and I got to go feed the cow. It's like, boom, okay, now we've got a hung jury, very different outcome. Hung jury meaning they couldn't reasonably reach a settlement, or they may go back in, and then of course, but once they come in and said they've reached it, and then it turns out they have it, well, that blows it ordinarily. All right, couple of things that we have here, JNOV. Judgment non obstante veredicto, which means judgment notwithstanding the verdict. If the judge finds that there was no evidence to sustain the verdict, then the judge will oftentimes enter this. Well, not oftentimes, but will rarely enter this. Ordinarily, there's some small amount of fact that went the right way for either party, and the verdict is sustainable. But there are cases where a judge has said, no, I'm going to turn this over. Because a judge is stepping on a jury in the American jury system, we love juries, hard to sustain, but also known that judges oftentimes take even thin cases and go to the jury with the hopes that the jury will say, this case is thin, there's no facts. Once we get to either the jury verdict or the JNOV, we then enter judgment, okay? And the judgment lets us set forth, this is $750,000, and you will not ever again step foot on this property, whatever the things are. That's going to be written out so that it's very clear, and we can always use that. Shortly after this time, we must bring post-trial motions. That is, we must give that court the opportunity to correct any errors in its proceedings. All right? And once the court rules upon that, then we go to appeal. As I stated in an earlier lecture, appeal in civil court is a matter of right. You always get an appeal. That doesn't mean the court ultimately has to hear it, but you do have the right to get there. Let me make one comment that judgment doesn't mean payment. All right, you can have all the judgments you want, but you may not get paid. Payment is a separate matter, and collection is something we talk about, I think, later in the course. Garnishment, oftentimes you may go right to bankruptcy court once you get a judgment against somebody. You can see that's a fairly involved process. So over time, we've begun to look at alternative dispute resolution. But this is also a system that has some challenges. Let me walk you through it kind of quickly. Sophisticated parties desire the AAA, which is the American Arbitration Association, to resolve their disputes rather than a court. For instance, if I get in an auto accident with an uninsured motorist, my auto insurance company says I have to go into uninsured motorist arbitration. Now, the states have begun to open it up so that there's actually court supervised arbitration, but ordinarily I get to pick an arbitrator, my company picks an arbitrator, the two of them pick an arbitrator. And that's ordinarily how all these arbitration agreements happen. All right. One of the places you're going to see them a lot, NASD, which is now FINRA, is how old these slides are. It's been FINRA for 4 or 5 years. I haven't updated it. If you're dealing with a stockbroker and you think that they're churning your file, you're not going to ordinarily be able to sue them in court unless you can prove fraud or something like that, which is really hard to prove. We'll get to that much later. You're going to have to go to arbitration. And guess what? Most arbitration favors the broker. Why? Well, because the brokerage house will be there next week too. And so anybody who's operating as an arbitrator may kind of want the gig where, hey, the broker picked me as an arbitrator. Kaboom, kaboom, kaboom. I hope you can follow that. So we've seen some studies that the insurance companies, the brokers, others have advantage, and that's why they're putting these clauses into the contract to make them enforceable. They oftentimes have the individual sign or initial that we agree that this arbitration is going to happen. There are great advantages to it for everybody. Even given those disadvantages, it is faster, it's more certain, it's quicker. We don't have quite the staging, the drama of the trial courtroom. We may have 1 or 2 days of hearings. We may not even have hearings. We may just submit it all in paper. We can all agree this is what's going to happen. Here's my statement against my broker. Here's my broker's statement against me. Let me make another comment here. Most businesses have records of everything they did, and most customers don't have a record of anything they did. So guess who wins? The businesses, because they have a record. So, be careful if you're dealing individually with stuff, but also be aware that as you're a business owner, you need good records that are made simultaneous with the transaction. That's why every time I call Vanguard, they say, you will be on a recording line, or you may be on a recorded line. Well, now with digital storing, they can store that under my name, my account, date of transaction, and find this in 2 seconds. So I've got to worry about that. And then this relates to the way I used to teach. I used to have a panel of experts. So anyway, we got through that one pretty quickly. I'll go back one. Let me see if I can go back. What I used to do is have people be, I would have a panel of 3 people who would discuss particular cases. Kind of a neat way to teach, because it gets the students to really know that stuff really well, because I'm going to be the moderator and ask them questions. So let me back up one more. I think I've covered everything I wanted to. The rules of evidence in court can be a real hard place for us to get stuff into court, or to also be able to keep evidence out. A lot of that goes away in alternative dispute resolution. If it's marginally appropriate to bring it in, they consider it. They also consider whether this should have weight or not. Recently the Trump dossier flew up, and I think most courts would kind of look at all of this and go, none of this is corroborated. All the other news agencies said, we're not publishing this because we can't find anybody who will say this is true. It might come in an ADR type of thing, but they may just go, we looked at this, we couldn't find any corroborative evidence, therefore we don't consider it in our final opinion. But they would have looked at it. In a court, you couldn't get it in because it never got corroborated. So I don't know if that helps at all. But anyway, thanks for listening. A lot of fun. Take care of yourself. Have a great day. See ya.